morning, I'm Jenny.
And I am Cream, and you are watching Pretty Angel's new channel.
Truth is our priority. We provide justice to your curiosity. Here on Pretty Angels News, we bring you the latest and most credible news of the day.
How wonderful we are, Jenny. Ladies and gentlemen, today we will delve into a topic of utmost significance in our rapidly evolving world.
Join us today as we discuss digital technology and the future of intellectual property law.
In this digital age, we find ourselves on the cusp of remarkable advancements and unprecedented challenges. As technology continues to revolutionize our society, it is imperative that we adapt our legal frameworks to ensure the protection and innovation of intellectual property.
It feels close to home, Cream. I cannot wait to discuss the profound impact of digital technology on intellectual property and offer insights into the future of intellectual property law.
I couldn't agree more with you, Jenny. First and foremost, we must understand that what digital technology exactly means. Digital technology refers to digital devices, systems, and resources that aid in creating, storing, and managing data. An important aspect of digital technology is information technology, which encompasses the use of computers to process data and information.
This is why digital technology has become a transformative force. The advent of the internet, coupled with the proliferation of smartphones and other digital devices, has revolutionized the way we create, consume, and distribute creative works.
In my opinion, AI plays a crucial role due to its potential to change how we live, work, and play. It has been effectively used in business to automate tasks traditionally performed by humans, such as customer service work, lead generation, fraud detection, and quality control.
However, do the output images produced by these generators qualify as genuine artistic choices that can be protected by copyright? And who holds the rights that the final creation of these computer-generated works? This remains a puzzling question.
Consequently, it could be argued that the person who financed the project, or the person who arranged for AI coding, even the person who provides any input for creation of the work, they could be considered as the rightful owners.
So, artists are increasingly employing AI in their creative process. This gives rise to intriguing legal inquiries that will either need to be resolved through judicial decisions or new legislation. While questions of subsistence and ownership will likely be addressed over time, it seems improbable that machines will ever possess their own legal rights.
In Thailand, according to Section 4 of Copyright Act, an author is defined as a person who creates or produces any work that qualifies for copyright protection under this act. This indicates that the law only safeguards the right of humans, not AI.
Similarly, in the United States of America, copyright law does not explicitly address artificial intelligence or even human authorship of original art. Copyright cannot be attributed to the AI itself. Section 306 of the Copyright Act protects original work of authorship, implying the involvement of a human in the creative process. The Act clearly states that human requirements, the U.S. Copyright Office will register an original work of authorship provided that the work was created by a human being. Therefore, according to the current regulations, AI-generated art remains ownerless.
The boundaries between digital technology and intellectual property law have become increasingly blurred, challenging the traditional concept of intellectual property. As a society, we find ourselves navigating uncharted territory, where the intersection of digital technology and intellectual property law has become exceedingly intricate. In this new landscape, the notion of intellectual property faces unprecedented challenges.
While every country has made efforts to protect intellectual property rights, there is no universal solution. The future of intellectual property law lies in finding a delicate balance between fostering innovation and safeguarding creators' rights.
Furthermore, as technology continues to advance, it is crucial for intellectual property laws to adapt accordingly. Legislation needs to be agile and responsive, capable of addressing emerging challenges, and safeguarding intellectual property law in digital era. Policymakers must engage in continuous dialogue with technology experts, creators, and industry leaders to ensure that laws are not only effective but also future-proof.
This collaboration will enable us to identify and address the legal gaps that arise as technology progresses, protecting the rights of creators and serving the interests of society as a whole. In conclusion, digital technology has fundamentally transformed the landscape of intellectual property law. As we stand at the thresholds of an unprecedented era of technological advancements, it is imperative that we adapt our legal frameworks to ensure the protection and promotion of intellectual property.
Together, let us embrace the opportunity presented by digital technology while also safeguarding the rights of creators and fostering a vibrant culture of innovation. And that concludes today's news from Pretty Angels. Once again, I am Cream.
And I'm Jenny, bringing you news from around the world, uniting us towards a shared direction at the United Rear Center. Thank you for joining us today. Have a great day.